Mr. Gautam Kumar. Mr. Gautam Kumar is an assistant professor at UPES School of Law, Dehradun. Before joining UPES Dehradun, he worked as a research associate at National Law University, Delhi. His research areas include laser disclosure around gender rights, constitutional literacy, tribal land rights, forest rights, and social movements. These research and legal advocacies among women, tribals, and student communities were carried out in northeastern states, southern states, Chhattisgarh, and Uttar Pradesh. Previously, Mr. Gautam Kumar has worked with the Center for Social Justice and Access to Justice initiatives. These initiatives included constitutional literacy, gender and minority rights, advocacy for minorities, women groups, school and college students, law and policy intervention for prisoners, and capacity building workshops or training for students, civil society, and marginalized communities in Chhattisgarh and Jharkhand. Mr. Gautam Kumar is further associated as a consultant with Bhopal based the Analysis Law and Policy Consulting and Dehradun based Social Development for Communities Foundation and assist them on various environmental and climate justice projects. Mr. Gautam Kumar is interested in questions pertaining to energy and climate justice, constitutional literacy, access to justice, law and development. With this brief introduction, I request Mr. Gautam Kumar to deliver a lecture on either lecture or presentation on the PIL and the impact of PIL and judicial activism on environment and sustainable development. I welcome Mr. Gautam Kumar.
Thank you. Thank you so much, sir. I hope I'm audible to
You
everyone.
are audible. You are audible.
Thank you so much for giving me this opportunity to interact with the students. And thank you for laying down such a robust introduction and a robust framework and putting the direction in which this discussion has to go. Also, thank you to Anubhav for laying down how the PIL started, be it from Hushanara Khatun, Sunil Batra case, Environment Matter. This is how the PIL started. So my specific topic is to the impact of PIL and judicial activism on environment protection. So to just lay down the agenda for the discussion and the topics which I will be touching in my presentation. So first, very briefly, I will touch upon the framework for environment protection under the Constitution. Then we will come to public interest litigation and scope of the writ jurisdiction in environmental cases. Pretty much covered by Anubhav's presentation, but we will try to touch upon that. Then we will specifically come to the role played by judiciary in establishing environment law principles. So through different case law, the Supreme Court have tried to incorporate, establish, or maybe the principles which are already existent in the national or international environment law discourse, they have tried to adopt. So these principles include principles of absolute liability, polluters pay, precautionary, intergenerational equity. So through different cases, I will touch upon these topics. And then I will touch upon a topic which Sir also have touched upon in his introduction, that how the civil society have played role in utilizing the PIL for the social justice. So you will see that in these cases, which we are going to discuss, that the role of civil society is pretty much evident through these case law. Who have filed this case belong from where they belong. They are very much there, the part of society, and they have done a lot in the development of environmental jurisprudence. And the Supreme Court has been a very supportive to that argument. Now, to quickly cover, there are the constitutional principle first include 21. You will agree that you will not find any specific provision in part 3 of the Constitution which talks about environment protection, but through different case laws, or the Supreme Court has developed the jurisprudence on environment, where Article 21 covers the scope or encompasses the scopes of environment protection as fundamental right. Then under DPSP, you will find Article 48A. Then under fundamental duty, Article 51AG, you will find, which is talking about as a duty of the citizens. Then if you take upon two schedules under 11 and 12, which talks about the municipal corporations, they have designated have to establish committee for the protection of environment and the promotion of ecological balance in their panchayats and municipality. These are the constitutional framework. If you go on to talk about the legislative framework, this will include the very Water Act, Air Act, I know the very first after the Stockholm 1972, and the Indian trust with the environmental legislation starts in that phase. So from Air Act, Water Act, then the umbrella Environment Protection Act, Forest Conservation Act. And the very significant development happened when the parliament enacted FRA. So this has been very instrumental in recognizing the community rights for the forest product, and also recognize that these indigenous communities who are residing in the several parts of India, who are inherently the citizens of this country, have in a way contributed to protect the environment. They live with the environment, they interact with the environment. They do not have any worship methodology. They worship their trees, forest, mountains. So FRA is the very landmark legislation. Now coming to the scope that of PIL and writ jurisdiction. So a very predominant part of the existing environment law has developed in India through a careful judicial thinking by the constitutional courts, the Supreme Court and the High Court. Now, when we talk about the writ jurisdiction, the courts, the constitutional court exercise their power under 32 and 226 and have played a very pivotal role in interpreting Article 21, that is right to life and dignity, for the redressal of environmental grievances. Now, you can club this idea of Article 21, right to life and dignity, whereby the environmental for the purpose of interpreting the constitution and the statutes, ensuring social justice. Now, through different case law and principle, I'll come to this point that how the Supreme Court have, played its role in ensuring social justice and protection of human right from the environmental lens. So I will like to start from the very first case, which also Anubhav also touched upon, but I will go in a bit detail because it is related to the climate right and the very first time. Why I'm starting with this case is also the matter that it is a very recent one. On March 21st, 2024, the Supreme Court, MK Rajneet versus Union of India, the Supreme Court declared, not declared, but interpreted that in our constitutional discourse, there always existed a right against adverse effect of climate change. So again, this was the PIL. In 2019, a former public official who filed a PIL in the Supreme Court to protect the Great Indian Bustards from the threat of overhead wire lines, and because they were critically endangered and its number were declining day by day due to the threats, including collision with the power transmission lines. Now, let's also discuss that, not always in a celebration matter, that how the Supreme Court has done. I believe that the Supreme Court also, missed upon a very opportunity to do justice to the environmental cause. This judgment includes two orders. If you look the 2021 order, it's much stringent against the state action. So in the 2021 order I was talking about, so the Supreme Court is directing through its order that the existing overhead wire line be converted to underground, then appointed a committee to facilitate that what could be done with this high voltage underground power line. Maybe a border diverter could be installed on existing overload wire line to prevent collisions. I'll request other people on this discussion to kindly mute your audio, please. है ना? We will take the questions, है ना? Because it creates disturbance. Thank you. But when you come to the 2024 judgment by the then Chief Justice D.Y. Chandrachud, uh, the Supreme Court withdrew its blanket order to lay all high tension cable underground. Instead, the court appointed a 7-member committee and tasked them to determine how to best protect the Great Indian Bustard. Then, if you read, it's a 57-page small judgment. The Supreme Court is going, tracking the India's commitment on renewable power, net zero, and but the earlier order, which was there in the 2021, it's somehow getting diluted. But again, they are reading into a new right, that is right against the adverse effect of climate change. One thing also I want to highlight in the environmental jurisprudence is the approach of looking towards it. It's a very anthropocentric to ecocentric approach. I just want to highlight this. There is a long debate happening in the academia that the Supreme Court judgment or the academic research which are going on is very anthropocentric. We need to have an ecocentric approach. So this is where I was commenting that the Supreme Court missed an opportunity. The case was for the Great Indian Bustard. It was not for the creating a reading down Article 21 humans and all. It has a very maybe a human civilization have that kind of a nature that we keep ourselves at the very center of every problem. So this was the chance that the Supreme Court could have taken an ecocentric approach. So now, moving ahead, Anvo also in his presentation mentioned the Ratlam. Why Ratlam is important in environmental jurisprudence, that it was the very first case in the 1990 where the municipal body of the Ratlam had failed to perform its duty of ensuring establishment of a proper drainage system on the ground, and which was creating a lot of disease. And the Supreme Court had introduced the concept of PIL for the first time and had observed that the responsible municipal council constituted for the precise purpose. And you can't take the you can't take the defense that your financial inability is not allowing you to take care of it. So Ratlam became the very first case where laying down the principle of environmental jurisprudence and treating PIL for environment protection. Now, from here, let's go by principle and how different cases of the Supreme Court has contributed. So the first principle is the absolute liability. It came in MC Mehta versus Union of India, 1987. This is the case which is also known as the oleum gas leak. So the absolute liability principle which got developed by the Supreme Court in the landmark oleum gas leak. This principle is a modified and stricter version of a strict liability. The students who have studied contract and torts, you are aware that there existed a principle of strict liability. So the Supreme Court modified this principle of strict liability and introduced specifically to deal with the incident involving hazardous or dangerous industries, and they introduced absolute liability. So it holds that an enterprise engaged in hazardous or inherently dangerous activity. You must emphasize the term that inherently dangerous activity is absolutely liable, will be absolutely liable to compensate for any harm caused by such activity, regardless of any defense, because there is an inherently presumption that these activities are dangerous in nature. So this case, MC Mehta, 1987, became a cornerstone for environmental law in India and strengthened environmental protection by creating a stricter standard of liability for industries which are inherently engaged in hazardous activity. Now, on the same very principle, there is another case, that is Indian Council for Enviro Legal Action versus Union of India. This is 1996. This is also called as the sludge cases. So what was the company involved was manufacturing acids. And though they shut down their business in a particular locality, the sludge discharge from the industry remained as a lethal waste for a very long time. And what was this happening? What was this doing? It was destroying the whole village by spreading disease. Deaths were being, skyrocketing, disasters, health disasters. So in this case, emphasis was laid down on the absolute liability of the industries in meeting the cost for remedial action as well as compensation for the loss and suffering. So the Supreme Court here, in a manner, you can say that the Supreme Court re-examined and reiterated the principle of absolute liability. Now, the next principle we would talk about is polluters pay. You must be aware that there is a World Commission on Environment and Development. So it was the first time that in their report suggested that the environment cost of economic activity shall be internalized by the enterprises. Now, again, there is a different institution which talks about, and where from there it comes to a different convention. It is OECD, Cooperation and Organization of Economic Cooperation and Development. For the first time, they agreed to base their environmental policies on polluters pay, and it was recommended as an essential economic efficiency measure to internalize environmental costs. And the Supreme Court picked upon this in the judgment of Velour Citizen Welfare. So what was happening here, that untreated effluents of tyrannies and industries were being directly discharged in the river. I guess the name of the river is, if I'm pronouncing it correctly, it's Palar or Palar. That was the main source of water supply for the residents of Velour in Tamil Nadu. Now, the court observed that the polluter pay principle here means that the absolute liability for harm to the environment extends not only to compensate the victim of the pollution, but to the cost of restoring the environmental degradation. Supreme Court is going beyond the absolute liability principle, that though you are absolutely right, responsible for it, but you are also responsible to compensate, and restoring the environmental degradation that your activity have caused. So remediation of the damaged environment is part of the process of sustainable development, and such the polluter is liable to pay the cost of individual who are suffering as well as the cost of reviving the damaged ecology. So this was Velour Citizen. Now, next principle, these principles are not in any particular order. So the next one is precautionary principle. It is a suggestive idea. The precautionary principle, the idea is to, if an action or a policy has a potential of causing harm to the environment or human health, and there is maybe scientific uncertainty about the extent that how much of a harm it will create, there is no robust research that is available. So in those circumstances, it is better to take precautions in advance, so to minimize the harm. If you go back to the international covenant, the Rio Declaration on Environment and Development, the principle 15, specifically talk about this precautionary principle. It states that where there are threat of serious or irreversible damages, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures. Now, from where then again the Supreme Court in the Velour Citizen that we discussed previously, applied this and declared that the precautionary principle is an essential feature of the sustainable development. And it laid down 3 criterias. I guess the criterias are environmental measures by the state government and the authority, that they must anticipate and prevent an attack that may cause environmental degradation. And it also highlighted that where could there be a threat of serious or irreversible damages, there should not be used as a reason for postponing. Same like principle 15 of the Rio Declaration, Supreme Court is reiterating in Velour Citizens. And onus of proof, it is very important in the court system. The onus of proof lies on whom? So onus of proof is on the actor or maybe the industry, the developer, to show that their action is environmentally not dangerous. Otherwise, they are presumed that they were dangerous. Now, the same principle, on the same precautionary principle, Anvo touched upon this case, that is MC Mehta versus Union of India 97, that is Taj trapezium. So again, principle of precautionary principle, Supreme Court is applying here, and the yellowing of the Taj Mahal. So what was happening, that there was some research through some expert committee, and they proved that the Taj trapezium zone in the Agra were using coke based fuels, for their industry. So the Supreme Court held that the industries which are already been identified by the uh, PCB, Pollution Control Board, as a potential polluter had to change over to natural gas. They have to shift so that smoke and things are not generated, and you shift to the clean fuels. So the Supreme Court said that those who are already been identified as a polluter by the Pollution Control Board as a potential polluter had to change to natural gas. And those who were not in a position, maybe there could be industry who are not into position to shift their fuel, uh, they were uh, they were not allowed to function in that declared Taj trapezium zone. So this was again precautionary principle. Now, the very important and principle, and very enshrined in the very constitutional jurisprudence, is the public trust doctrine. So it is a very legal principle that plays a crucial role in environmental law and policy. It asserts that natural resources, the coal, air, water, wildlife, the hills, the mountains, the forest, are preserved for public use. And what is government? Government is obligated to protect and maintain these resources for the public benefit. So the idea of a custodian, the time and again we have heard that the Supreme Court is the custodian of fundamental right. So the public trust doctrine in a similar manner emphasized that the natural resources the state has to protect is as a custodian, and the public has the right over it. So the doctrine emphasized that the states hold these resources in trust for the present and future generation, ensuring that they remain available for the public enjoyment and sustainable use. Now, this was again a very famous case. Again, MC Mehta filed a PIL. This was again 1997. This is MC Mehta versus Kamal Nath. So this was happening in Himachal Pradesh. And how the Supreme Court picked upon it is also interesting. And highlighted that there came a phase where the news articles, the Supreme Court started entertaining through their letters, and they made it a public interest litigation. So in this case also, there was an article in 96 in Indian Express. The Kamal Nath dares the mighty Beas or something was the title of that Indian Express report, which was published in 1996. And that report alleged that this person, who was the then Minister of Environment and Forest, was involved in privatization of a government lease land, for a construction of a private hotel which was being run by their kins. And the issue is that the land was located in the basin of Beas River in Himachal, and was a very ecological sensitive prone area for flooding and everything. So in order to protect that mottle, the owners diverted the natural river flow by heavy machinery. So this tempering caused significant ecological damage. And Mr. Mehta filed again PIL under the 32 of the Constitution, and the Supreme Court here established or emphasized the doctrine on public trust, and it held that the natural resources, river, water, air, are held by the state in the trust of the public and cannot be alienated for private or commercial purposes. I guess this was Justice Kuldeep Singh. He observed that the Beas River is a natural resource and part of public trust, and its diversion for private benefit was violation of the constitutional ethos. So this was public trust. Now, the another doctrine which is now very much into you are hearing about it in all the international convention, UNFCCC or IPCC, everywhere, that is doctrine of sustainable development. So again, it was World Commission on Environment and Development, WECD, So in its report, you must be familiar, that is the famous report, which is called as the Brundtland report. They defined the concept of sustainable development for the first time. And according to this report, sustainable development means the kind of a development that meets the need of the present without compromising the ability of the future generation to meet their own needs. Now, the Supreme Court, which the judgment is very here. There is a one civil society organization working in Dehradun itself, that is RLEK. You must have studied in their environment law class. The Rural Litigation Entitlement Kendra versus State of UP. This is 1985. This is also called as the Doon Valley case, or it is also called as the famous limestone quarrying case. So Doon Valley, which is located where I'm residing as of now, located in the Mussoorie Hills, witnessed an extensive limestone mining operation starting from the 1950s, and it continued till 80s. And the negative consequences of these mining operation become pretty much evident. Now the RLEK, Dehradun, they registered a writ again under Article 32 of the Constitution, and the Supreme Court ordered for the immediate closure of the limestone quarrying. There was a Bhargav committee appointed which categorized these mines as category A, B, C. So all these categories were shut down by the Supreme Court, and the Supreme Court made this observation that we are not oblivious of the fact that natural resources have got to be tapped for the purpose of development, but what cannot forget at the same time that tapping of the resources have to be done with the requisite attention and care, so that ecology and the environment may not be affected. Because you understand that the Himalayans areas are very much sensitive. The last time in the monsoon, you must have heard about the landslides. The Char Dham Yatra got hampered because of one of the minor landslide. In Himachal, you are listening the news of landslide. There are rigorous constructions taking place in these areas. They are very sensitive zones. So the Supreme Court is reiterating in the Rural Litigation and Entitlement Kendra versus State of UP about the idea of sustainable development and scrap the mining in these areas. Now, another interesting principle is intergenerational equity. It may sound similar to an extent to sustainable development, but its idea is very much more broader in terms of social justice, and I believe that it also takes into its consideration the idea that the climate change or environmental degradation do not have similar impact on everybody. So environmental consequences have differential impact on different classes. So one of who are the largest contributor may be adapting to the scenario, but one who are the least contributor, the farmers and all, they are the major sufferer, because climate change will happen, crop rotation cycle will be affected, they will be at the very receiving end. So this principle, intergenerational equity, environmental law and policy, is a very key concept. Its focus is on fairness and justice within the current generation of people we are living on this planet. It emphasizes equitable distribution of environmental resources, and also the equitable distribution of responsibilities among all individuals and community, regardless of their socioeconomic status. You can go back and read a lot. There have been a lot of research that the environmental degradation and climate change have differential impact on the different gender, caste, class. So intergenerational equity ensures that the benefit and burden both of the environment action and policies are shared fairly among the people. And if you go to this sustainable development goal, SDG 10, to an extent talks about reducing inequality within and among countries. So they're not talking about the communities. There are different IPCC or UNFCC event which takes care of the community also, but SDG 10 to an extent talks about intergenerational equity. The cases by the Supreme Court, which could be said that they touched upon the idea of intergenerational equity. One, I guess it could be Andhra Pradesh Pollution Control Board versus MV Naidu. This is 1992, where the Supreme Court is explicitly recognizing the principle of intergenerational equity through these cases, and it is emphasizing that environment must be protected both for the present and future generation, and that development activity must take into account their potential impact on the environment. And there is another case, it got also mentioned in the previous presentation, that is T. N. Godavarman. Through this case, the Supreme Court issued numerous order invoking the principle of intergenerational equity. So it has repeatedly emphasized the need to conserve forest cover for future generation, and have placed a lot of restriction on the diversion of forest land for the non-forest purpose. This is the very issue which is there in the FRA also. If you go to the places where there are tribal dominated places, be it in Madhya Pradesh, Chhattisgarh, Jharkhand, a lot of manipulations nowadays are being done to convert the forest land for the non-forest purpose, and maybe to facilitate mining activities. So these are again hampering the principle of intergenerational equity and the order of the courts, in T. N. Godavarman, or the ethos of the Constitution in the 21. So now the last thing which I said that I will be talk about, that is the role of the civil society in ensuring the environmental protection, is very much evident. All these PIL, and be it under Article 32, there could be a lot of cases, and I can go on, but I'll try to sum up in a way, because I have given you a gist that how the Supreme Court has used the PIL and used this mechanism for ensuring and maybe enshrining the environmental jurisprudence in our country, and also how the individuals, the academic organizations, the civil society, the non-governmental organization, they have also utilized the concept of PIL for ensuring social justice, environmental justice. So RLEK is there filing the case, MC Mehta as an individual filing the case, the Great Indian Bustard, again, a motivated public official is filing PIL there. So they have utilized this space, and ensuring that environmental protection. I guess that the civil society, academia are serving as a bridge between the government, public policy institutions, and they are advocating for sustainable practices, holding policymakers accountable, and fostering community participation in the environmental governance. And I also recognize that in this manner, the Indian judiciary has proved itself to be a strategic partner, I would say, in promoting environmental governance, upholding rule of law, and ensuring fair balance between the protection of environment, social commitment, and developmental consideration of the country. So these, in a whole, gives you paints a picture that how the Supreme Court, starting from the Ratlam to the 2024 M. Rajneet versus Union of India, through how they have treated PILs, and have the whole. In one word, you can say that the whole environmental jurisprudence in India has developed through PIL, and the civil society organization everywhere in here in Dehradun. There is RLEK, there is SDC Foundation, there are West Warriors. They are doing a lot, engaging with the system, engaging with the courts, to make place better. So I guess I have given you a gist of how the PIL and the judicial activism in the environmental matter have been very positive. They have given a lot of concept principles. So I guess I was able to do justice to the topic. So I'll take a pause here. Thank you so much, Professor Reddy, for inviting me. Thank you. Over to you.
Thank you for your outstanding presentation, Mr. Gautam Kumar. It is very nice. And Mr. Gautam Kumar has covered constitutional framework and legal framework relating to the environment. And he has also mentioned the role of Supreme Court in the matters relating to social justice and environmental protection. He has covered key environmental law principles such as polluter pays principle, precautionary principle, doctrine of sustainable development, and intergovernmental equity. And he has also touched the role of civil society in protecting the environment. Thank you for your nice presentation, and it is very outstanding presentation. I'm
Thank
very
you.
grateful to you, Gautam
Thank you.
Kumar.
Thank you so much, sir. Thank you.
Now, my question to Mr. Gautam Kumar: what is the scope of writ jurisdiction in environmental protection?
I guess I started even in your introduction, and when the Anubhav was laying down the process where the PIL and the Supreme Court started entertaining PIL, and I also in my very first presentation have touched upon this aspect that the PIL and the scope of writ jurisdiction. So all the PIL, which are there, which have established the redressal mechanism for environmental grievances, have been entertained by the Supreme Court under Article 32. They are writ jurisdiction. So, be it the Great Indian Bustard case, be it MC Mehta case,
Okay.
be it Indian Council of Enviro Legal,
Okay, you have covered at the beginning.
yeah.
You have
So
covered.
these all the cases predominantly suggest that the Supreme Court is entertaining, and giving scope for the PIL to, and
Yes, sir. Mr. Anubhav also has covered
yes,
some of the
yes,
cases
yes.
which have been
So this is
brought
pretty
under
much
PIL.
evident that
Have been brought under PIL. He has also
yes,
covered. Yes, yes. Now I
yes.
understood, sir. See, one more, the last question. We used to come across judicial overreach. Judicial overreach.
Okay.
So, what is the fundamental difference between judicial activism and judicial overreach?
As I concluded, this might take some time. As I concluded in my presentation, in my discussion, I said that the judicial activism for environment matter per se has been very positive.
Okay.
Maybe judicial overreach will go beyond the idea of activism, and then it will, taking away the executive power into its hand, taking away the legislative power into its hands. Actually, there is a book by Professor Arun Trivengadam, The Contextual Analysis to the Constitution of India. So the professor is mapping the different phases in the Supreme Court and how it is reacting. You also, in your introduction, talked about that the initial first decade, the Supreme Court were silent,
Silent.
they are not entertaining. But
Yeah.
as and when the executive are becoming weak, or the DPSP interpretation, the case is starting, be it Minerva Mail on these cases, the Supreme Court is taking, very preactive role. Uh, but I will still refrain from calling it as a judicial overreach, because these cases have, established very the idea of constitutional ethos protecting individual uh, liberty and all. But one thing I will mention, maybe Anubhav as a litigating advocate in the Supreme Court could substantiate on it, that judicial overreach is also a matter of nowadays you are seeking as a pick and choose. The courts, I don't know whether they are doing intentionally or not. Sometimes they pick upon some matter, they want to entertain it. Sometimes they do not pick upon the matter and directly said that this is a legislative domain, this is an executive domain, we will
Okay.
not entertain those matter. But sometimes very effortlessly they entertain on those matter. So I hope I was able to give you some idea.
Yes, sir. So thank you.
Thank you, sir.
Conclude the session. I express my sincere gratitude to Mr. Anubhav Kumar and Mr. Gautam Kumar for their participation at our event. Both of their presentations very informative and thought-provoking. We look forward to collaborate with Mr. Anubhav Kumar and Mr. Gautam Kumar again in the future. We also thank Dr. G. Vanishri Madam from IBS Bangalore, Dr. Kesari from Faculty of Law, ICFI Foundation for Higher Education, and students of BA and MA Economics of ICFI School of Social Sciences, and other participants for their participation in the webinar. And we thank the Sakshi management of Sakshi Media for giving us this opportunity to conduct the webinars. And we also thank the in charge of Sakshi Education, Mr. Chaitanya Kranti, for giving us this opportunity and his active participation in conducting the webinars successfully for the last 2 months. Thank you, one and all. Thank you, Mr. Anubhav and Gautam.
Thank you so much, sir, for
Both
this
of your
opportunity.
presentations were very good.
Thank you, sir. Thank you.